Yes. This session is now adjourned, and we will meet at what time would that be?
After 10
12:50
minutes.
UTC. 12:50 UTC after 10 minutes.
Hi, Dr. Govin. Can you hear me?
Yes.
Yes, it's very nice to see you. And Mishi,
Hi,
nice to meet you
Sheeta.
again.
Yeah,
Hi,
good to see you again. How are
see
you?
you again. Good. How are you? It's the morning there.
Yes, yes.
Quite early morning in New York time, I think.
Not very early. It's 7:50. So we have some time to start, or we start at 7:50.
No, we will start in another 30 seconds.
Okay.
A session on social media governance, content, and data. The first speaker is, I will just introduce Mishi Chaudhary. She is a technology lawyer with law practice in New York, USA, legal director of the Software Freedom Law Center. She advises business startups in USA, Europe, India, China, Korea. As director, Software Freedom Law Center, working on intersection of law, technology, and policy. She is quite eminently well versed with the social media issues. Our second speaker is Sheepa Lakshmi, has around 20 years of experience in the area of data protection, privacy, and cybersecurity, served as a MAG member of the UNIGF from 2014 to 16. She has specialized in internet governance at University of Malta, and she is executive director of TIFA Foundation. So I will say a little bit context to this session, as today we are in the much of the content generated in the social media platforms consisting of user generated postings, pictures, videos. An exponential growth in the internet users has enabled the user created content that has fueled the educational, professional, commercial, entertainment, and social networks online. There is an explosion of harmful content ranging from hate propaganda to disinformation to revenge porn. An intermediary liability clause exists which gives these platforms a safe harbor protection. However, this liability framework is now under serious scrutiny. Some say social media platforms don't moderate user content strictly enough, while others complain that moderation restricts their free expression online. The governments around the world are coming up with new regulations to control the information on these platforms. The basic aim is to see how harmful content spread on social media platform is minimized. With this context, I will ask Mishi to say 3 minutes first.
Okay. Thank you, Dr. Govind. Can everybody hear me?
Yes.
Okay, perfect. So, a few things I would say is that um, social media platforms, they do regularly engage in all kinds of content moderation. I understand that most of you, if not all of you, at least must be engaging with one kind of social media platform or the other to express yourselves. Now, why this becomes such an important topic right now is because the social media companies themselves have metamorphosized into something much bigger. What started as small platform companies out of California have now gone on to acquire markets as well as users in various parts of the world who use the platforms for different purposes. Now, in the beginning, of course, something very simple, easygoing rules because everything seemed very much nostalgic about connecting with older people, having some voyeurism there, now has converted it into being used for business purposes, but most important, as an important part of our democratic rights execution. How we express ourselves, how we receive information is also now determined by these platforms. And that's why the role of the companies, what they show us and how our various feeds, because they're all obviously tailor-made to us, are tweaked, becomes extremely important, because that's where they have the secret sauce to show and to tell us where the content is coming from. Now, this obviously, as Dr. Govind said, that governments all around the world are trying to come up with laws. This has been going on for a very long time. One major thing is the companies have become very big. But the second thing is also that the governments now understand the importance of social media and platform companies as well. Not only the politicians or the government officers use these platforms to communicate to people, but they have also understood how to use it during elections for sending political messages which are targeted to people. Now, you can imagine when power, which is government, and money, which are the companies, when they get together, things are going to get a little more complicated. So the companies also do have only one business model. The business model of the internet, even till date, stays advertising. And for that, they must collect enough behavior. So if you and I are going to interact with these platforms, and if we don't give them behavior, whether it is outrage, whether it is likes, whether it is fighting online, then they don't really get enough data about us, and that the advertising is not very accurate. That is the basis of all of this. And that's why we see a little bit of hesitation and trepidation in terms of taking down everything which we see online. And if we forget that context, then we will always be thinking about laws like Section 230, or if you're in India, you're thinking about Section 79, or no matter where else in the part of the world you are, we think about intermediary liability matters. But I want to say this major big picture is important to see where we are. The governments also are ostensibly coming up with laws to check disinformation and misinformation, which is somewhat a part of their job. But often in many places, we've seen that these laws are used for censorship by proxy. And that's why everybody has a very strong reaction. Now, but because companies have not done a very good job of taking care of all kind of policies to be very consistent with them, or to be very transparent about what they are doing, there are some genuine demands which also go unanswered. And so we as users feel that we are caught between these crosshairs and these power dynamics of tug of war between power and big money. And then we do not know where we are headed. As users, we would like to use the platforms, and but without all these issues. So I would say that within 3 minutes, if that covers it, Dr. Govind.
Thank you. We move to Shita Lakshmi now.
Okay, can you hear me? Can you hear me?
Yes, yes.
Yeah,
Okay. Okay. This is a very default questions in the webinar. Can you hear me? Okay, first of all, thank you very much for APSIG to invite me speaking in this session with Nishi and Dr. Govind. I would like to start with saying that there is no one silver bullet in drafting a comprehensive policy to govern social media content in data. Firstly, because the medium itself are pretty complex, the intertwined between infrastructure and content and a series of decision makers around the medium. And secondly, the process of governing itself is also evolving. Dr. Rosana Radu, my supervisor for my thesis, but also the author of Evolution of Internet Governance, she broke it down to 4 periods of Internet governance. The first period was in 1970s to 1994, when it was dominated by informal governance and focused on technical standard. Internet was seen as a technical matter and pretty much a homogeneous domain. Governance has its own form, combining between public and private partners, private initiatives. The second one is in 1995 until 2004, when the role of private sectors, market-oriented approach, and globalizations is on the agenda. Digital market began to prosper in 1990, and given the hands-off approach of the US government, any attempt to regulate internet was condemned. Then the third one, it was in 2005 until 2015, when hybrid configuration were brought to the center, privileging cross-sectoral partnership in a global regulatory arrangement, like, for example, the Internet Governance Forum, the one that you discussed earlier with the 3 distinguished speakers. And as a policy discussion become more relevant to the internet, the multi-stakeholder came into the pictures, and many of them give concern from the different point of view regarding authority, legitimacy, and accountability of the internet governance. Post 2015, new power trends indicate a stronger position for a limited number of companies and states, like Mishi was mentioning before. The evolution of internet governance, the technological advancement of and realpolitik also affecting the evolution of defining internet intermediate liability. In my presentation later, we can discuss about it. I give you the floor, Dr. Gavin. Thank you very much.
Thank you, Shita Lakshmi, for within the time limit confining to that. So now we have around 29 minutes. So we will be last 10 minutes we will leave for Q&A, and for before that I will first ask Mishi to make a 10 minutes presentation, and then Shita Lakshmi can make 10 minutes.
Nishi, please unmute yourself.
Mishi, you have to unmute.
We have presentation on the screen.
Can you all see a presentation? At least I can see, and I'm not controlling this presentation.
Do you want to run it on your own? You can do it.
Yeah, it's me. Whenever you wish to change the slide, you may please just say next slide. I'll change it.
Okay. Okay, great. See, this is like I have no control over my own content. Perfect for a content moderation presentation. Somebody else is going to control what you see, despite the fact that this is supposed to be user-generated content, which is my content. So let's begin. But at any point in time in this presentation, we can just stay on the first slide. We don't have to move to the other slide. Because anytime during this presentation, if you have questions or you would like to discuss something, just stop me there. And you can always take the slides home and read them. Dr. Govind is a very good principal and moderator who made sure that there was enough information for you on the slides. I'm a bare bones slides person. But you can always take the slides at home, read them, discuss them, perhaps send questions later. Let's try to have a conversation, because slides are never as important. Let me say a few things, and then we would move to something which happened last night in the United States, which is why I had to add a few slides at the last minute. So social media platforms regularly engage in content moderation. Now, I have been asked to touch upon that aspect of it, and Shita would touch upon the intermediary liability aspect, or what is the liability here of platforms. Now, when you hear the term liability, I hope your eyes don't glaze over. It only means that when at the very beginning of the internet revolution, when we were looking at it in the 1990s, it was pretty clear to the United States legislature that no e-commerce or no other such companies who distribute information online will be able to operate if they are continuously being held responsible for what others do on their platforms. So in the context, I would explain in India's context, which loves having a lot of criminal legislation for everything. India used to have something very similar to eBay, which was called Bazi.com. And early on in the early aughts, we saw that its CEO was once arrested because a CD, a pornographic, which so-called pornography, but it was just captured two people engaged in a sexual act. That CD was being sold on his platform called Bazi.com. This is like something is being sold on eBay by X person, but instead of going after that X person, the CEO was arrested. And it was colloquially known as the DPS CD or something which was going on. But to give a wider context, that time the Indian legislature got together and also said, we can't hold CEOs responsible for what people are doing on their platforms. And they thought we will look at what the US has done. And by that time, US had already done, please move on to the next slide. This particular section, if you can move on to the next slide, please. 47 USC section 230. This is the Communication Decency Act. 47 is the name of the code under which this section is found. And this is a really, really important factor here because this is how liability, secondary liability is decided. So when various governments saw that what US had done was that they ensured that the companies would not be responsible for what was the content which was put online. Read this later, but just understand what the section does. If you can move on to the next slide, please. This portion which has been marked in yellow, which says no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Now, some of the people have called this as the 26 words which made the internet. You would see a book by that title, but this is also very, very important. And why this is also important is because anytime anybody these days has a problem with the large platform companies, they go and talk about this particular section without getting into the details of the section, without examining what the law actually says and what does it do. They are always trying to attack this section and trying to change it. In the past few months, we've seen the US government asking FCC, which has zero jurisdiction on this particular matter, to say, why don't you hold a consultation on it? In India, we've been seeing various versions of how this safe harbor is provided. Now, before I move on to my content moderation part, I would say is that why you don't get the treatment of a publisher or a speaker is that because you are not responsible for what others are posting on the platform. That's the first bit. The second bit is that despite all of that, the platforms would like to control what kind of content is available on their platforms. Not only just because of law, but also because you and I as users don't always want to be spammed by a lot of stuff or looking at content which we may not like actually. And because they're reliant on the users, so they do all that kind of tweaking, moderating, and changes, etc. as well. The other thing I would say is that this section does have two other parts. People usually don't talk about that part, and I don't want to go in the legalities so much, but one must look at those other parts because those other parts give the powers to the platforms to make their own policies and not be held responsible for. So if Twitter makes a policy that I will only allow X kind of stuff and be not allow Y kind of stuff, then you can't tell Twitter, why do you have these policies? Because it's against the law. You can have other reasons, you can have other demands, but you can't talk about the law here. Now, can we move to the next slide, please? So I would ask you, urge you to remember.
Sorry, 2 minutes only.
Oh, wow. Okay. So I haven't even started basically, but anyway, here are the few fundamentals which I would say you must all remember if anytime you're thinking about these issues. First, if a private entity provides a forum of speech, it is not ordinarily constrained by the First Amendment because the private entity is not a state actor. Now, I know First Amendment is America's right of free speech, but no matter where in the world you are, how this is constructed is that Facebook, Instagram, Twitter, etc., these are private parties. You don't have rights which can be enforced against them. If your government takes away your right of free speech and expression, most constitutions would at least provide some kind of remedy. But you don't have the same rights enforceable against the private platforms. And that's why the private entity can exercise editorial discretion over the speech and the speakers in the forum. Because you must see that the platforms themselves are not under that obligation to maintain your rights. Now, the platforms can change and can have policies based on what they would like to show on the platform. Second, content moderation, which means that a lot of downranking, depublication, or sometimes outright censorship of information or blocking of user accounts also is always contextual. And we must appreciate what the context around it. And the third is that AI is not the magic bullet that on everything which is done automatedly or has automatic filters will solve the problem. If Dr. Govind, this last two slides I'm going to show, I would say, so yesterday, this happened. Sorry, first, can we go to the next slide? So in the United States, the #1 topic which was trending was diaper dawn. And no, can we move on to the previous slide? Yes, this one. Because the trend was diaper dawn, the President of the United States issued this tweet, which is called, for purpose of national security, Section 230 must be immediately terminated. It's an interesting thing. And why it is interesting is to tell you that how much any law which gives a little protection to the companies becomes the target of people who do not like, who may be in power, but do not like what is trending or what people are discussing. Now, I would urge you to look what diaper dawn is. If you've not already guessed, this is obviously somebody addressing the current president. And then there was a video by the young kids who have memes, etc. So instead of having either a sense of humor or trying to understand that there are rights which companies have, the president directly went after 230. Now, I did say that there's a lot about other things, about what content moderation actually is, what is right, what is wrong, how much it is already broken, and what can be done to fix it. It's a dangerous job. A lot of it is inconsistent and confusing. There is very little transparency. And I'm not talking about the numbers-based transparency reports which companies give out. There's very little transparency about how we understand these matters. And a lot of time that automated tools end up in censoring. And my other slides would talk about that. And I would also urge you to read them to say how some organizations have come together to propose principles by which the companies, etc., can always adhere to. And those principles are also mentioned here. But overall, I would leave you with the understanding that there is a big major issue in terms of when our urges are, we must stop all of this. We want companies to do something, we want government to do something, but I would urge you to not forget that there's a lot of nuance. And if we do not give this kind of protection, it's going to be very hard for businesses to operate, but it will also be hard for us to be able to use these platforms freely. Having said that, the problems of disinformation, misinformation, behavioral collection, all are real problems. I don't think I can actually cover everything, so I will let the person who's smarter than I am and more expert, Sheeta Lakshmi and Dr. Govind, take over. But I'm very happy to discuss later.
Yeah, thank you, Mishi. Now, Sheeta Lakshmi, please.
Yeah. Can I share my own screen then? It's easier.
Yeah.
Yeah, sure, Sheeta, please.
Yes. Can you see it now? So, sorry. Can you see this?
It's loading. Yeah.
Okay. I would like to follow up because we have very little time. What Missy was mentioned, and I'm not more expert than her. I'm speaking to talk about what is internet intermediate liability. Basically, broadly defined as an entity which provides services from one point to another on the internet. It could be in the form of infrastructures, access to the internet, and or facilitating two or more points in the transfer of data. This is just a broad definitions of intermediate liability. Gave a very good definitions of the internet intermediary. They divided into two. First is as a conduits, basically merely technical providers of internet access or transmission services and do not interfere with content they are transmitting. Basically related to the Wi-Fi providers or internet service provider. The second is host, the one that Nishi was mentioning, providers of the content services, and for instance, online platforms and storage services. So it's more adding some content into it based on different algorithm methods such as ranking and visibility. I don't need to tell you more about the section 230 as Missy has mentioned. I just would like to show you the evolutions of the defining internet intermediate liability starting from 1996 when this article was mentioned. The second one, as far as my research goes, is the US election in 2016 when there was an event of Russia interference in the US elections. And I think there was an honest act in 2017 that requires platform to make reasonable efforts to bar foreign entities from purchasing certain categories of political advertisement during campaign season. So these are the turning point of why then internet intermediate become more liable, or discussions about this coming to happen. It's also because a lot of terrorism acts went on using the social media. And I think in 2017, Theresa May was addressing this as well in the UNGA, in the United Nations General Assembly. The second one is the U.S. elections in 2020, as Missy has mentioned, that Donald Trump have this executive order to repeal this section 230. In 2015, the announcement civil society, there was a proposed framework to safeguard the actions of government in defining liability for internet intermediary. There are 6 conditions. The first one is intermediary should be shielded from liability from third-party content. The content must not be required to be restricted without an order by a judicial authority. Requests for restriction of content must be clear, be unambiguous, and follow due process. Laws and content restriction orders and practices must comply with the test and necessity and proportionality. Laws and content restriction policy and practices must respect due process. Transparency and accountability must be fulfilled into laws and content restriction policy and practices. These are the ideal situations of social media back then in 2015, before the elections, before the 2016 elections in the US and the Russia interference. So it was the a golden period where people really trusted the social media, put their data freely, religiously sometimes, without asking more due process. But it changed quickly after the U.S. election in 2016 and all the terrorism attacks that also involve social media. Now, I would like to go deeper a bit. You can read it later in Singapore and Germany, because these two countries are quite advanced in developing regulations to social media or through the internet intermediate liability. Singapore has this protection from online falsehoods and manipulation act, and Germany has this network enforcement act, or NetzDG. Very quickly, the process, this is because this is my thesis. So it was, for Singapore, it's very quick. The government submitted green paper to the parliament in January. There was a public hearings and paper submissions, and it was submitted the recommendation in September. They tabled the POFMA bill in the parliament in April. It was approved in May, and the act came into effect in October. So it is basically around 2 years of the making. Germany also very quick. This is because one of the reasons is because the Angela Merkel has opened the migration policies, and it creates a lot of turbulence in Germany. So it was tabled in March 14 by German cabinet, notified the EU commissions, and there was a consultation in May. In June, a public hearing, and in October 1st, the SDG entered into force. And the social media providers have 3 months to implement the law. And in January 1st, 2016, NetzDG being implemented by the providers of social networks. So I would like to show you how different it is, how Germany looking at the governing social media or governing internet intermediary in Singapore and Germany. So Germany really focuses on the social network platforms with more 2 million users in Germany, and basically hate speech that violates 22 provision under Germany's criminal code, and relies on user complaints for the network decisions. While in Singapore, the internet access for provided the provider that part of the Telecommunications Act, which is include telecom system and services, internet intermediaries, and internet intermediary services. Yeah, so it's very big definitions and very big scope, and also online falsehood and manipulation, and gives full authority to any ministers to make decision whether this is falsehood or whether this is manipulations. So the compliance.
We can confine within 1 minute more.
Okay, thank you. So I have one more slide after this. Yeah, I think you can read it by yourself, but the point is that Germany and Singapore has very two different way of implementations and way of understanding how to define the liability towards the internet intermediary. For Singapore, for example, they have this correction directions and also stop communication. So it can range from the entity into individuals. It could also cut your access to the content itself. This is my last slide. I think defining intermediaries and liabilities is an ongoing discussions. It's never finished. And I think there are a lot of conversations also around the world, including in my country, Indonesia, about this. As Missy was mentioned, United States is at the center of these discussions. I think many countries trying to regulate, but what really defines how the Twitter, Facebook, or Instagram, or all the big tech companies coming from the US, and the discussion between those big companies with the US Senate, and through that GDPR does have an impact towards privacy and personal data protections. This is also being reflected in my country, for example, Indonesia, but also part of the evaluation report of the GDPR that many countries are trying to adopt this. The technical knowledge is very important to develop regulations. There were some studies made by Manila Principles saying that many governments are amending their regulations or changing their regulations due to their more advanced technical knowledge. And I think what Nishi was mentioning earlier about the behavioral and advertisement, I totally agree. I think we should discuss beyond publisher versus non-publisher. I guess we should go more discussing internet reliability into their processes, into what data they are collected, what kind of their business processes, and what kind of advertising that they are doing. So those are monopoly or anti-monopoly as well. So those are the issues that I guess necessary to be discussed. I guess I
Thank you.
stop here.
Thank you, Shita Lakshmi. Now, floor is open to the participants for Q&A.
Wow, Dr. Govind, that was a whirlwind of information in 20 minutes.
Okay, thank you. There is a question to Mishi, or anyone, any participant would like to directly ask questions to the speakers? Mubashir, any participant want to ask directly to the speakers? They can ask.
I think
Dr.
there are
Govind,
some
yeah,
questions and
there is a
comments in the
question
chat.
from Shraddha Pan. Okay, please.
Please. Can you read out? Yeah.
Yes. So Mishi partially answered my question in the chat.
Yeah, I was still typing, but please go ahead.
Right. So, I mean, you really, that's a very interesting point about having a different regime. But usually we tend to hear people who are either arguing for regulation or arguing against regulation. No one's talking about a different regime altogether. So could you expand a little more on what exactly is this new regime that you're thinking about?
Sure. I do think that the new regime would look more, will definitely have more regulatory interference in terms of how the tech companies operate. And that may not necessarily be just about intermediary liability or content moderation. Right now, we all get the news is made by the major things like what content is shown or what content is removed, etc. But that's not where the power lies, and that's not where the impact is. That's the impact portion. That's why the antitrust investigations are very important, because that would ensure that the monopoly structures are different. That is why the data protection regimes which are now coming up are also very, very important. Because as I started in the very beginning to say that the companies are no longer those small startups which were only giving you a platform to come and express yourselves. So because they are now doing so much more than what we understood previously, that's why the regime will also have to be expanded. Now, the 230 bit, or its corresponding way of looking at the India's, for example, the intermediary liability rules under Section 79, they also jam up a lot of stuff which does not really belong there. For example, what is available to speak publicly should not be confused with what you and I would like to speak safely without having any interference with one another or whoever it is directed at. But if you see the current intermediary liability rules, they also talk about traceability and breaking of end-to-end encryption. That's why I said that you're right about the fact everybody wants to say, oh, more regulation, no regulation. But the laws are not that simple. And once written, the laws are very difficult to undo. And most of you who've seen how laws work or are lawyers, it becomes very complicated even with the very tiny words here and there in order to how businesses are shaped. That's why nuanced thinking is what is required rather than saying, I don't like this. I don't like what the liberals are saying. I don't like what the conservatives are saying, or whatever political ideology you don't like it. Because that's not how the business would run.
Mishi, we can move to the another question.
Yes, we have Vivek Vashi. Please go ahead.
Yeah.
Hello, Mishi. Thank you for sharing your views. I'm just curious because as we know, in many countries, there are existing laws that censor some of the contents on social media and any other platform as well, as long as it's on the internet, due to the grounds from national security law perspectives. So if we're moving forward, do you think this kind of social media content discussions are best judged from a global perspective, or it has to be taken, a local context have to be taken into very serious consideration into making such laws?
I think that Chita Lakshmi can answer that also, because she did talk about the various other countries. She mentioned Singapore, Germany, etc. You're right. I would just say that we are watching that a lot of national security laws and intelligence and everything else is now intertwined. Geopolitics is intertwined in terms of which apps we can access or we cannot access. Companies have banned TikTok in one country or the other. So this is true that all these issues are very much closely related. But as much as internet makes us feel that we are all together, sensibilities of different countries are very different. I aspire to have an internet with a First Amendment kind of a right, where everybody is free to speak whatever they want or access whatever they want. But that may not be the reality. But I think Sheeta can address this question better.
Yeah, I think Dr. Griffin, you still mute.
Yeah, Sheeta, you want to take it?
Well, I don't have more to add, Mishi, because I agree with you. And I think that's really the questions. I think the big discussion in internet governance is about the fragmenting of those laws, because every law has its own context, and every country has its own social politics, like what I said in Germany and in Singapore, and even in my country, in Indonesia, and also in the US as well. So if every country has its own definitions and every country has its own liability sanctions or implementation, that will be very confusing for the internet to work. So that I guess that those are the big questions of for the internet governance people to discuss further about this.
I'm afraid we are really over time. I think there are many questions on the chat box I'm seeing, and if individual speakers can answer them by individual capacity, or so I would ask the speakers in the last, what is the one challenge you feel you advise the participants on this issue? One line each.
Yeah, Mishi, you can go ahead
first. Okay. Well, so one thing I would say is don't buy into the nuanced destruction machine that social media is, that every discussion is black or white or simple to go on one side or the other. And second, also think about new businesses and the smaller ones who do not have big legal teams like Facebook, Twitter, Instagram, who want to enter the market, who might give you better products. And as a user, we should demand. And third, I would say is that users are very, very powerful as citizens as well as users of companies. So demand better rights and better products.
Yeah, I think for my my final take is that well, this discussions on social media governance is really heavily rely on the discussion in the US. I guess I received a question from Nepal and also from my own country or other countries in the South. I guess we also have to be part of the discussions. It's not only about what Facebook and Twitter is discussing in the US, but also should also include people from the South to take decisions as well. I think European Union is also discussing about the how to curate the content, also moderation. And I think if those decisions is being made in the other part of the countries and not including our part of the country, that will be something that we have to discuss further.
Thank you. I will end the session, and thank you very much for the two eminent speakers, Sheeta Lakshmi and Nishi Chaudhary. I hope participants enjoyed this session. from the point of view of social media governance, and they can always contact the speakers for their wonderful knowledge in this sphere. And Mishi and Sheeta Lakshmi are the best in the world in this space. Thank you very much.
Thank you very much.
Thank you, Dr. Govind. And thank you,
Thank you,
everyone.
Mishi. Thank you,
Thanks,
Dr.
Sheeta. Good
Govind.
to see you
Very
again.
nice to see you again. Bye-bye.
Yeah, stay safe.